FAQs, the Code on Wages, 2019. What is the Code on Wages, 2019? It's a unified law that consolidates 4 older wage-related legislations. Approved on August 8, 2019, it establishes consistent rules for minimum wages, timely payments, and equal pay across India, simplifying the regulatory framework. Which previous laws does it replace? The code replaces 4 existing laws: the Payment of Wages Act, 1936, the Minimum Wages Act, 1948, the Payment of Bonus Act, 1965, and the Equal Remuneration Act, 1976. This consolidation significantly streamlines compliance requirements. What are the main benefits for workers? Workers gain universal minimum wage protections regardless of job type or location, guaranteed timely wage payments, equal pay regardless of gender, and expanded legal safeguards covering both organized and unorganized sector employees. How does it help employers? Employers benefit from a substantially reduced compliance burden by navigating just one unified law instead of 4 separate ones. The code also provides a standardized definition of wages, simplifying calculations for various benefits and statutory obligations. What is the floor wage mentioned in the code? The floor wage establishes a baseline minimum wage set by the central government. No state government can set minimum wages below this threshold, helping prevent significant wage disparities between different states and regions. When did the code come into effect? The code received presidential assent on August 8, 2019, and was subsequently published in the Official Gazette of India. It was formally enacted in the 70th year of the Republic after passage by both houses of Parliament. What is the Code on Wages, 2019? A comprehensive law that consolidates 4 older wage-related laws into one unified code. It establishes consistent regulations for fair wages, timely payments, and equal pay for all workers throughout India. When was this law officially approved? The code received presidential assent on August 8, 2019, after being passed by both houses of Parliament following thorough consultations with stakeholders. Which previous laws does this code replace? It replaces 4 separate laws: the Payment of Wages Act, 1936, the Minimum Wages Act, 1948, the Payment of Bonus Act, 1965, and the Equal Remuneration Act, 1976. What are the main benefits of this new code? Workers benefit from universal minimum wage standards, timely wage payments, and gender-neutral pay practices. Employers enjoy reduced compliance burdens. The code extends protections to both organized and unorganized sector employees throughout India. Does this law apply throughout India? Yes, it applies to the entire country, including all states and union territories. Implementation may occur in phases to ensure smooth transition from previous regulations. This landmark legislation represents a significant modernization of India's labor framework, simultaneously simplifying compliance while strengthening worker protections nationwide. What is the Code on Wages, 2019? The Code on Wages is comprehensive legislation that consolidates 4 previous wage-related laws into a single unified framework. It governs wage payments, establishes minimum wage standards, regulates bonus payments, and ensures equal pay for equal work regardless of gender. This code replaced the Payment of Wages Act, 1936, Minimum Wages Act, 1948, Payment of Bonus Act, 1965, and Equal Remuneration Act, 1976. When was this law passed? The Code on Wages was approved by both houses of Parliament and received the President's assent on August 8, 2019, marking a significant legislative milestone in the 70th year of the Republic of India. Where does this law apply? This legislation extends to the entire territory of India, encompassing all states and union territories. It provides protections for workers across both the organized sector, formal employment in companies and establishments, and the unorganized sector, informal employment. Importantly, the law's provisions apply to all employees regardless of their wage level. When did the law come into effect? The code allows for strategic phased implementation. The central government has the authority to establish different effective dates for various provisions across different states through official notifications. This graduated approach facilitates a seamless transition from previous legislation while allowing adequate time for administrative systems to adapt. Why was this new code created? The Code on Wages was developed to simplify and rationalize India's complex labor law framework by consolidating 4 separate legislations into one cohesive code. This unification creates greater clarity for both employers and employees, reduces compliance complexity, and represents a significant advancement in the modernization and streamlining of India's labor regulations. What is meant by accounting year in the code? The accounting year refers to the financial period from April 1st to March 31st of the following year. This is the standard financial year followed throughout India for accounting and taxation purposes. What role does the advisory board play? The advisory board, either central or state, is established under Section 42 of the Code to provide expert advice to the government on wage-related matters. These boards include representatives from employers, employees, and independent experts who help ensure fair and effective implementation of the code. How is agricultural income tax law relevant to the code? Agricultural income tax law refers to any legislation that currently governs taxation on income derived from agricultural activities. This definition is important because it affects how certain types of income are calculated and treated under the Code on Wages. What does appellate authority do under the code? The appellate authority is officially appointed by the appropriate government to hear appeals against decisions made by wage authorities. If you disagree with a ruling related to wages, this is the authority you would approach to have your case reconsidered. Who decides which government is the appropriate government? The central government serves as the appropriate government for establishments operated by or under central government authority, including railways, mines, and major corporations established by central acts. For all other establishments, the state government is considered the appropriate government. What constitutes a company according to the code? A company follows the definition provided in Section 220 of the Companies Act 2013. This includes registered corporate entities that exist as separate legal entities from their owners, with perpetual succession and a common seal. What is meant by appropriate government under the code? The appropriate government refers to which government authority, central or state, has jurisdiction over your workplace. The central government serves as the appropriate authority for establishments under its control, including railways, mines, major ports, banks, and telecom companies. For all other establishments, the state government functions as the appropriate government. How do I know if my industry is a controlled industry? A controlled industry is one that the central government has declared requires national oversight in the public interest through a central act. In these industries, the central government automatically becomes the appropriate governing authority regardless of location. These industries typically operate under special regulations governing their production, supply chain, and pricing structures. What is the difference between a contractor and contract labor? A contractor is an entity or individual engaged to deliver specific outcomes or supply workers to your establishment. Contract labor refers to the workers themselves who are hired through these contractors to perform designated tasks, while maintaining their employment relationship with a contractor, rather than becoming direct employees of your establishment. Who are advisory boards and what do they do? Advisory boards, central or state, are expert committees established under Section 42 of the Code that provides specialized guidance on wage law implementation. These boards comprise balanced representation from employers, employees, and independent specialists who advise the government on minimum wage determinations and other critical labor matters. What role does a certifying officer play? A certifying officer is a government-appointed official responsible for validating and approving crucial employment documentation, particularly standing orders, workplace regulations. They ensure all employment terms comply with current labor laws and verify that proper legal procedures are followed when establishing or modifying workplace policies. What is a company under the Companies Act? A company is a business entity registered under the Companies Act 2013 or earlier company laws. This includes public and private companies, those with limited or unlimited liability, and companies with or without share capital. It functions as a distinct legal entity with its own rights, responsibilities, and legal standing. Who is considered a contractor in business operations? A contractor is an individual or organization hired to deliver specific results or complete particular projects for a business. Unlike vendors who simply supply goods, contractors take responsibility for producing outcomes through specialized services such as construction, maintenance, IT development, or other specialized functions outside the business's core operations. What defines contract labor and how is it different from regular employment? Contract labor comprises workers engaged through a contractor to perform specific tasks for a company without becoming direct employees. These workers maintain their primary employment relationship with a contractor rather than with a company where they work, even when the company supervises their day-to-day activities. This arrangement differs from regular employment in terms of benefits, job security, and legal protections. What is a controlled industry and why is it important? A controlled industry is one that the central government has designated for special regulation in the public interest. Industries like defense, pharmaceuticals, and utilities fall under this category and must adhere to additional regulations governing operations, production, distribution, and pricing. These controls help safeguard public welfare, ensure national security, and maintain essential services. What role does a certifying officer play in labor regulations? A certifying officer is a government-appointed official who validates and approves crucial employment documents, particularly standing orders, workplace rules. They ensure workplace policies comply with labor laws and protect workers' rights. Their official certification provides legal legitimacy to employment terms and workplace governance structures. What is a cooperative society? A cooperative society is an organization registered under the Cooperative Societies Act or equivalent state legislation. These societies form when individuals voluntarily unite to achieve shared economic objectives through a jointly owned, democratically controlled enterprise. They function on principles of self-help, mutual assistance, and collective action to advance their members' financial well-being. How is a corporation different from other business entities? A corporation is a distinct legal entity established through central or state acts, excluding companies and cooperative societies. What sets corporations apart is their separate legal identity, for they exist independently of their owners, have perpetual succession, maintain their own official seal, and possess the capacity to own property, enter contracts, and engage in legal proceedings under their own name. What qualifies as a direct tax? A direct tax is any tax paid directly to the government that cannot be transferred to another party. Common examples include income tax under the Income Tax Act, surtax on company profits, agricultural income tax, and any other tax specifically designated as direct by the central government. These taxes are imposed directly on your earnings or assets rather than on transactions or goods. Who is considered an employer under labor laws? An employer is any individual who engages one or more workers in their establishment, whether directly or through intermediaries. This definition encompasses factory operators, mine owners, and heads of government departments. The defining characteristic is having authority over workers and bearing responsibility for their working conditions and remuneration. What constitutes an establishment in business regulations? An establishment refers to any premises where industrial, commercial, or occupational activities occur. This comprehensive term includes factories, offices, shops, mines, and various workplaces where business operations, manufacturing processes, or services are conducted. Establishments may be operated by private individuals, corporate entities, or government organizations. FAQs about employee definition. Who is considered an employee under the law? An employee is any person hired by an establishment to perform work for wages or salary. This includes individuals in skilled, semi-skilled, or unskilled roles, as well as those in manual, operational, supervisory, managerial, administrative, technical, or clerical positions. The definition encompasses full-time, part-time, and temporary workers in both public and private organizations. What distinguishes an employee from an independent contractor? The key difference is control. If your employer determines what work you do and how you perform it, you're typically classified as an employee. Independent contractors generally have autonomy to decide how they complete assignments and manage their own schedules. Are remote workers considered employees? Yes, individuals working from home or other remote locations remain classified as employees if they work under an employer's control and supervision. Your workplace location does not affect your employment status. Does the definition include people on probation? Yes, workers serving probationary periods maintain their status as employees under the law. Probationary status does not exempt you from employee protections and rights. Are casual and seasonal workers considered employees? Yes, casual workers hired for occasional or seasonal work are still classified as employees. The temporary nature of your engagement does not alter your status under labor regulations. Who is not considered an employee under this definition? This definition excludes members of the armed forces, apprentices, governed by the Apprentices Act, 1961, independent contractors genuinely operating their own businesses, and volunteers who provide services without compensation. Can my contract classify me as a non-employee if I function as an employee? No. Your employee status is determined by the actual working relationship, not merely contractual terms. Courts can override contract language if your real working conditions demonstrate your functioning as an employee. Employer definition FAQs. Who is considered an employer under labor law? An employer is any individual or entity that engages and compensates one or more workers. This includes natural persons, corporations, partnerships, limited liability companies, government agencies, and factory operators. The defining characteristics are the authority to control work performance and the obligation to pay wages. Can government bodies be employers? Yes. Within government establishments, the designated authority or department head serves as the employer. These officials act on behalf of the state and bear responsibility for implementing public sector employment regulations while ensuring adherence to applicable labor laws. Who is considered the employer in a factory setting? In manufacturing environments, the occupier, as defined in the Factories Act, or the officially designated manager assumes the role of employer. This individual bears legal responsibility for worker safety, welfare provisions, and compliance with industrial regulations. Are contractors considered employers? Yes. Contractors who engage workers for specific projects are classified as employers and bear full legal responsibilities toward their workforce. This includes timely wage payment, ensuring workplace safety, and maintaining compliance with all statutory labor requirements. What happens to employer responsibilities when an employer dies? Upon an employer's death, their legal representative, executor or heir, assumes the employer role and inherits all associated responsibilities. This includes honoring existing employment contracts, settling outstanding compensation, and fulfilling other employment-related obligations. Why is the employer definition important? This definition establishes legal accountability for labor law compliance, including fair wage payment, benefit provision, workplace safety standards, and other employment conditions. Precise classification is crucial for proper application of labor regulations, determination of legal liability, and effective resolution of employment disputes. What qualifies as an establishment under labor law? An establishment is any location, physical or virtual, where business, trade, manufacturing, or occupational activities are conducted. This encompasses private businesses, commercial entities, and government operations. Even organizations without physical premises can qualify if they engage in systematic business activities. How is a factory legally defined? Under Section 2(m) of the Factories Act, 1948, a factory is any premises, including surrounding areas, where manufacturing processes occur. The definition applies when 10+ workers are working or have worked on any day in the preceding 12 months. This classification applies regardless of whether power-assisted machinery is used. What constitutes a government establishment? Government establishments include offices or departments at central, state, or local government levels. These encompass ministries, public departments, municipal offices, statutory bodies, public sector companies, and government-funded institutions. Unlike private entities, they primarily operate for public service rather than profit generation. How does the Income Tax Act impact employment relationships? The Income Tax Act, 1961 regulates taxation of employment income, including salaries, benefits, and allowable deductions. It establishes tax obligations for both employers and employees, defines taxable perquisites, and specifies TDS requirements. The Act also outlines tax exemptions available for certain employment benefits and compensation components. Understanding these legal definitions is crucial for determining applicable regulations, ensuring compliance, and properly establishing rights and responsibilities in workplace contexts. What is an industrial dispute? An industrial dispute refers to any disagreement or conflict between employers and employees, or among workers themselves, concerning employment terms, working conditions, or termination of service. These disputes are formally defined under Section 2(k) of the Industrial Disputes Act, 1947. What are the main types of industrial disputes? Industrial disputes are primarily classified into two categories: collective disputes, conflicts between employers and groups of workers, typically represented by trade unions regarding wage negotiations, working hours, leave policies, workplace safety standards, or terms of collective bargaining agreements. Individual disputes, conflicts between an employer and a specific employee concerning issues such as wrongful dismissal, retrenchment, discrimination, performance assessment, or compensation entitlements. What issues commonly trigger collective industrial disputes? Wage determination. and payment structures, scheduling of work hours and rest periods, statutory and contractual leave entitlements, occupational health and safety standards, implementation of collective bargaining agreements. What issues frequently precipitate individual industrial disputes, allegations of wrongful or unfair termination, workplace discrimination or harassment claims, contested performance evaluations or ratings, disputes over interpretation of employment contracts, disagreements regarding compensation packages or benefits. How are industrial disputes resolved? Both categories of disputes are addressed through statutory mechanisms outlined in labor legislation, including conciliation proceedings, voluntary arbitration, and adjudication by specialized labor courts and industrial tribunals as prescribed by the appropriate governmental authorities. Individual disputes typically progress through internal grievance redressal mechanisms or mediation before advancing to formal legal forums. What is an inspector cum facilitator? An inspector cum facilitator is a government official who serves dual functions, enforcing labor law compliance through inspections while also guiding employers on improving workplace standards and worker welfare. These officials are formally appointed under Section 51(1) of the Act. What is meant by minimum wage? Minimum wage represents the legally mandated lowest compensation an employer must provide to workers, as established under Section 6. This essential baseline is calculated considering cost of living factors and varies by geographic region, industry type, and worker skill level. All employers must adhere to these minimum payment standards, regardless of their organization's size or structure. What is a notification in legal terms? A notification constitutes an official governmental communication published in the official gazette, either at national or state level. These formal publications serve as the government's primary mechanism for announcing new regulations, policy decisions, or statutory requirements to the public. Once published, notifications become legally enforceable from the specified implementation date. What does prescribed mean in labor regulations? When an element is prescribed, it has been formally established within the rules formulated by the appropriate governmental authority, central or state. This encompasses specific procedures, documentation formats, compliance timeframes, or methodologies that carry legal authority. Failure to follow prescribed elements can result in regulatory non-compliance and potential legal consequences. A thorough understanding of these fundamental terms helps employers and employees navigate their respective rights and obligations under current labor legislation more effectively. What does same work or work of a similar nature mean? Work requiring equivalent skill, effort, experience, and responsibility performed under comparable working conditions. Minor differences between jobs performed by different genders are not sufficient grounds for unequal pay or employment terms. How do we determine if skills are equal? Skills are considered equal when jobs require comparable levels of technical expertise, knowledge, equipment proficiency, problem-solving abilities, and specialized training. For instance, two employees operating identical machinery should receive equal compensation regardless of gender. What constitutes equal effort in a job? Equal effort encompasses similar levels of physical exertion, such as lifting, carrying, or standing, and mental engagement, including concentration, analysis, creative thinking, and decision-making. Evaluations must be based on objective job requirements rather than gender-based assumptions. How is equal experience assessed? Equal experience involves requiring similar tenure in the field, depth of practical knowledge, and understanding of industry challenges. Experience requirements should be objectively defined and consistently applied, with appropriate recognition of relevant experience gained in all sectors, including traditionally female-dominated industries. What defines equal responsibility? Equal responsibility involves comparable levels of outcome accountability, decision-making authority, supervisory duties, financial oversight, and impact on organizational objectives. For example, project managers overseeing similar-sized teams and budgets should be recognized as having equivalent responsibility regardless of gender or department affiliation. What is meant by state under the Act? A state includes any state in India as well as union territories, regions directly administered by India's central government. What does tribunal mean in this context? A tribunal is a specialized judicial body established to resolve specific disputes. In this act, it carries the same definition as in the Industrial Disputes Act of 1947, which created tribunals specifically for resolving employment-related conflicts. How is an establishment defined? An establishment refers to any physical location where business activities occur, including places of industry, trade, business, manufacturing, or any occupation. This definition also encompasses government establishments, Who qualifies as an employer? An employer is any person who employs workers in their establishment, either directly or through an intermediary acting on their behalf. The defining characteristic is having authority over the employment relationship. What is meant by appropriate government? The appropriate government indicates which governmental level has jurisdiction in the specific situation. The central government serves as the appropriate authority for establishments under central government control, central public sector enterprises, or railways. In all other cases, the state government holds jurisdiction. Who is considered an employee under the Act? An employee is any person employed for wages in an establishment, excluding apprentices. This encompasses workers performing any type of work for skilled, semi-skilled, unskilled, manual, supervisory, managerial, administrative, technical, or clerical. The critical requirement is receiving payment wages for their work. Understanding these definitions is crucial as they determine who receives protection under the Act and which authorities are responsible for enforcement across different scenarios. What are wages under the Act? Wages encompass all remuneration paid to an employee for their work. This includes base salary, various allowances, and any other form of compensation that an employer contractually agrees to pay. It represents the complete financial value an employee receives in exchange for their services. What components are included in wages? Basic pay, the core fixed amount in your compensation package, dearness allowance, additional compensation to offset inflation and rising living costs, retaining allowance, payments made to maintain employment during business downturns, special assignment payments, compensation for additional responsibilities, regular performance incentives, recurring bonuses based on work quality, the value of contractually agreed benefits, monetized perks. Why is the definition of wages important? A precise understanding of what constitutes wages ensures accurate calculation of various employment benefits for both parties. For employees, it directly affects overtime compensation, paid leave entitlements, social security contributions, and retirement benefits. For employers, it determines statutory compliance requirements, payroll obligations, and tax liabilities under labor laws. How are wages different from salary? While salary typically refers to a fixed amount paid regularly, usually monthly, wages is a comprehensive legal term encompassing salary plus various allowances and supplementary payments. This legal distinction becomes particularly significant when calculating statutory benefits, addressing employment disputes, or determining compliance with labor regulations. These definitions form the legal foundation for establishing employee compensation rights and corresponding employer obligations under national labor legislation. What components are excluded from the legal definition of wages? Labor laws specifically exclude 11 items: statutory bonuses, housing utility benefits, employer pension contributions, travel allowances, expense reimbursements, house rent allowance, court-ordered payments, overtime pay, sales commissions, gratuity payments, and retirement benefits. Why do these exclusions matter? For employers, understanding these exclusions ensures accurate calculation of statutory benefits, proper compliance with labor laws, and efficient payroll management. For employees, it clarifies which portions of their compensation package count toward benefit calculations. Are all bonuses excluded from wages? Only statutory bonuses payable under specific laws are excluded. Regular performance incentives that form part of your standard compensation may still count as wages. How are non-cash benefits handled in wage calculations? Benefits provided in kind, such as housing, utilities, and medical services, are generally excluded from wages. However, if these benefits exceed 15% of total wages, the excess amount may be counted as wages under certain provisions. Which allowances are excluded from wage calculations? Transportation allowances, travel concessions, and housing rent allowances are specifically excluded. These are considered reimbursements for specific expenses rather than compensation for work performed. These exclusions directly impact calculations for provident fund contributions, gratuity payments, and various other statutory benefits and obligations under labor laws. What components are considered wages under labor law? Wages primarily include basic pay and dearness allowance. They typically exclude bonuses, housing benefits, employer pension contributions, travel allowances, and expense reimbursements. However, if these excluded items exceed 50% of total remuneration, the excess amount is counted as wages for legal purposes. How are non-monetary, in-kind, benefits treated in wage calculations? Benefits provided as goods or services, such as meals, accommodation, or utilities are counted as wages. but only up to 15% of total wages. For instance, if you receive $20,000 in cash compensation and $5,000 worth of meals, only $3,000 of those meals would be considered part of your wages. Who qualifies as a worker under labor laws? The definition includes anyone employed in any industry who performs work for payment, whether manual, skilled, technical, clerical, or supervisory. This broad classification encompasses journalists, sales promotion employees, apprentices, contract workers, and part-time employees to ensure wide labor law protection. Which professionals are excluded from the worker definition? Exclusions include military personnel, Army, Navy, Air Force, police officers, high-level managers with decision-making authority, supervisors earning over $15,000 monthly, and family members of the employer working in the business. How do wage calculation rules prevent discrimination? Labor law includes specific provisions requiring certain allowances be included when calculating wages for gender equality assessments. This prevents employers from concealing gender-based wage discrimination through complex compensation structures or allowance classifications. Understanding these definitions is crucial as they determine eligibility for various labor protections, statutory benefits, and employer obligations. Courts consistently look beyond job titles to examine the actual nature of work relationships when applying these definitions in legal disputes. What is the legal definition of a worker? A worker is any person employed in any industry performing manual, unskilled, skilled, technical, operational, clerical, or supervisory work for payment, whether through express or implied terms. This inclusive definition ensures labor protections extend across diverse sectors and employment arrangements. Why is the worker definition important? This classification determines eligibility for crucial labor protections, social security benefits, and workplace rights. It establishes the boundaries of coverage under various labor laws and helps both employers and employees understand their legal obligations and entitlements. Which specific professionals are included in the worker definition? Journalists, including reporters, editors, photographers, and other media professionals. Sales promotion employees engaged in product and service marketing, workers dismissed or laid off during pending labor disputes, apprentices working under apprenticeship agreements, contract workers hired through intermediary contractors, part-time workers performing duties similar to full-time employees. Who is not considered a worker under this definition? Military personnel, including Air Force, Army, and Navy, police officers and prison staff, individuals primarily in managerial or administrative roles, with significant decision-making authority, supervisors earning more than $15,000 monthly, employees of specifically excluded establishments, family members of the employer working in the family business or household. Can my job title affect whether I am classified as a worker? No, your actual duties and working relationship matter more than your formal job title. Courts consistently examine the substantive nature of employment relationships rather than paper designations. This prevents employers from circumventing labor laws through misleading job classifications. How does this definition impact labor protections? Those meeting the worker definition are entitled to comprehensive labor protections, including fair wages, regulated working hours, safe working conditions, and statutory benefits like provident fund and gratuity. Individuals excluded from this classification may receive different protections under separate laws or regulations applicable to their specific circumstances. Who is legally considered a worker? A worker is any person employed in any industry to perform manual, unskilled, skilled, technical, operational, clerical, or supervisory work for payment, whether through express or implied terms. This includes journalists, sales promotion employees, apprentices, contract workers, and part-time workers, military personnel, police officers, high-level managers earning above $15,000 monthly, and family members working in family businesses are excluded. What constitutes gender-based wage discrimination? Gender-based wage discrimination occurs when employees of different genders receive unequal pay for the same work or work of similar nature. This includes differences in basic pay, overtime, bonuses, performance incentives, and any other compensation components when performing equivalent tasks with similar responsibilities. Can employers reduce wages to achieve gender pay parity? No, employers cannot reduce any employee's wages to comply with gender equality requirements. Pay parity must be achieved by raising the wages of the underpaid gender group to match their counterparts performing equivalent work. Reducing wages to create artificial parity is prohibited and punishable under law. Are there protections against gender discrimination in hiring? Yes, employers cannot discriminate based on gender during any stage of recruitment for the same or similar work. This covers job advertisements, selection criteria, interview processes, and final hiring decisions. The only exceptions are positions where employment of a particular gender is legally restricted or prohibited. How are disputes about same or similar work resolved? Disputes are resolved through a formal process handled by a government-appointed authority. This process includes filing a detailed complaint, preliminary assessment, thorough investigation, and issuance of a binding decision. The authority conducts workplace visits, interviews relevant parties, and examines job descriptions to make determinations based on objective criteria. What penalties might employers face for non-compliance? Employers violating these provisions may face substantial financial penalties, mandated organizational reforms, and potential civil liability. Failure to comply with decisions from the appointed authority regarding wage discrimination can result in additional escalating penalties as prescribed by law. What happens if there's a dispute about whether two jobs are the same? When disagreements arise about work equivalency for wage discrimination purposes, the case is referred to a government-appointed authority for independent assessment, ensuring an objective evaluation based on established criteria. How do I file a complaint if I believe I'm doing similar work but paid less? Submit a detailed written complaint to the designated government department including your work responsibilities, documentation of wage differences, and a comprehensive comparison showing how your work parallels that of higher-paid colleagues, emphasizing similarities in job duties, required skills, and working conditions. How does the authority investigate these disputes? The authority conducts comprehensive investigations including on-site workplace assessments, structured interviews with relevant parties, thorough examination of official job descriptions, and comparative analysis against industry standards. Their evaluation focuses on key factors including required qualifications, level of responsibility, and workplace environment. Is the authority's decision final? The authority's determination is legally binding and requires prompt implementation within established deadlines. While parties may seek judicial review for perceived legal misapplications, such appeals must be filed within strict statutory time frames and do not automatically suspend implementation of the original decision. What happens if an employer ignores the authority's decision? Non-compliant employers face significant legal consequences, including substantial financial penalties, mandatory retroactive compensation with accrued interest, and escalating sanctions for deliberate violations, which may affect the company's legal standing and operational permissions. This guidance outlines the systematic process established to resolve work equivalency disputes in gender-based wage discrimination cases. The framework ensures equitable and evidence-based evaluation to determine whether different positions warrant equal compensation based on objective criteria. Who is required to pay minimum wages? Every employer must comply with minimum wage requirements regardless of company size, industry type, or whether workers are permanent, temporary, or contract-based. This fundamental obligation applies universally across all sectors without exception. Are there any exceptions to paying minimum wages? No exceptions exist that permit payment below the established minimum wage under any circumstances. The law maintains strict standards in this area to safeguard workers' rights to fair compensation. How often must minimum wages be paid? The obligation to pay minimum wages applies continuously for all hours worked. Employers must ensure that wage payments occur at regular intervals, typically not exceeding 1 month, as specified by labor regulations. What happens if an employer fails to pay minimum wages? Non-compliance with minimum wage provisions can result in significant penalties, including substantial fines, back wage payments with interest, and in serious cases, criminal prosecution. Government labor authorities conduct regular inspections and respond to complaints to enforce these provisions. What can workers do if they're paid below minimum wage? Workers who believe they're receiving less than minimum wage have the right to file formal complaints with the appropriate government labor authority. These complaints trigger official investigations, and workers are protected from retaliation for reporting violations. All employers must pay at least the minimum wage rate as officially notified by the government, with absolutely no exceptions permitted. Failure to comply may result in severe financial penalties, legal action, and damage to business reputation. Who has the authority to set minimum wages? The appropriate government, central or state, possesses the exclusive authority to establish, review, and revise minimum wages within their respective jurisdictions. These authorities ensure consistent implementation of wage standards nationwide. What types of minimum wages can be established? Minimum wages may be established for both time-based work, compensation based on hours worked, and piece rate work, compensation based on output produced. For piece rate workers, rates must be calibrated to ensure earnings at least equivalent to time-based minimum wage standards. How frequently are minimum wages reviewed? Minimum wages undergo mandatory review or revision at intervals not exceeding 5 years. These reviews incorporate critical factors such as cost of living adjustments, productivity metrics, and prevailing economic conditions.
Are there any exemptions to minimum wage requirements? None whatsoever. All employers must remunerate workers at or above the minimum wage rate officially notified by the government, with absolutely no exceptions permitted. This mandate applies universally across all sectors and industries regardless of organizational size or structure. How are wages calculated and dispersed? Wages may be structured by hour, day, month, or other government prescribed periods. Payment must be made via currency notes, check, or direct bank transfer. All compensation must be dispersed before the 7th day following the conclusion of the wage period, and no wage period may extend beyond 1 month. What consequences do employers face for non-compliance? Non-compliance triggers substantial penalties including significant financial sanctions and potential imprisonment for repeated violations. Workers retain the right to lodge formal complaints if they believe their compensation falls below mandated minimum wage rates. Employers bear responsibility for maintaining comprehensive and accurate documentation of all wage calculations and disbursements to employees. These records must remain accessible for examination by authorized regulatory authorities during compliance inspections. What are the different wage periods recognized by law? Minimum wages can be set hourly, for variable or casual work, daily, for day laborers, monthly, for permanent employees, or by any other period the appropriate government prescribes. The chosen wage period typically reflects the nature of employment and industry standards. How are wages calculated across different wage periods? Wages are calculated using government-prescribed methods that account for standard working hours, overtime with premium rates, statutory deductions, and conversion factors when switching between wage periods, such as monthly to hourly. These calculations ensure fair and consistent payment regardless of the wage period. Is there a maximum duration for wage periods? Yes. Wage periods cannot exceed 1 month. This rule ensures workers receive regular compensation and prevents extended periods without payment. When and how must wages be paid? Employers must pay wages on a working day before the 7th day following the end of the wage period. Payment must be made through currency notes, checks, or direct bank transfers to the employee's account. What record keeping is required for wage payments? Employers must maintain detailed and accurate records of all wage calculations and payments. These records must remain available for inspection by authorities to verify compliance with minimum wage laws. Understanding these regulations helps employers maintain legal compliance while ensuring employees can effectively exercise their rights regarding fair and timely wage payments. What factors must the government consider when setting minimum wages? The government must evaluate the worker's skill classification: unskilled, semi-skilled, skilled, or highly skilled, geographic location, to account for regional cost of living variations, work difficulty and physical demands, and industry-specific productivity standards. These primary factors establish the foundation for baseline minimum wage rates across different sectors. Are there additional factors that might affect minimum wage rates? Yes. The government may apply premium adjustments for adverse working conditions such as extreme temperatures or humidity, occupations with significant health and safety hazards, underground work environments, and alignment with prevailing wage rates for comparable positions in the region. Economic factors such as inflation and its impact on purchasing power are also considered when determining final minimum wage figures. Why doesn't the government create many different minimum wage rates? The government deliberately limits the number of minimum wage categories to maintain a balance between precision and practicality. An excessively complex wage system would create compliance challenges for employers, particularly small businesses, and make it difficult for workers to understand their entitlements. The approach prioritizes reasonable simplicity while still ensuring equitable compensation. How often are these minimum wage criteria reviewed? The criteria undergo formal review at intervals not exceeding 5 years, as mandated by regulatory frameworks. However, extraordinary economic circumstances such as rapid inflation or market disruptions may trigger interim reviews. This systematic approach ensures that minimum wage determinations remain responsive to changing economic conditions while providing stability for both employers and workers. Understanding these criteria helps employers maintain compliance with minimum wage regulations and empowers workers to advocate effectively for their rights to fair compensation under the law. What are the different ways minimum wages can be structured? Minimum wages come in 3 forms. 1. Basic rate plus cost of living allowance that adjusts with inflation. 2. Basic rate plus the value of concessions like subsidized housing or meals. Or 3. An all-inclusive single payment combining all components. All structures must meet the statutory minimum wage requirement. What factors determine minimum wage rates? Key factors include worker skill levels, unskilled to highly skilled, geographical location, reflecting regional cost differences, work difficulty, and industry productivity standards. Additional factors include challenging conditions, extreme temperatures, humidity, hazardous environments, underground work, and comparable wages for similar occupations. Who participates in the minimum wage determination process? The government either appoints balanced committees with equal employer and employee representation plus independent members limited to 1/3 of total membership, or publishes proposals for public feedback. Both approaches ensure diverse stakeholder input before finalizing decisions. How frequently are minimum wages revised? Minimum wages undergo review at least once every 5 years, with special reviews possible during economic disruptions like rapid inflation. New rates typically take effect 3 months after official Gazette notification, providing employers transition time for implementation. How does the government balance fairness across different sectors? The government strives for simplicity and minimum wage rates while ensuring fair compensation. Their approach combines stakeholder involvement, balanced representation, and transparent decision-making to protect worker interests while supporting employer needs and promoting economic development. A thorough understanding of these minimum wage aspects helps ensure compliance and enables effective participation in wage determination processes when stakeholder input is solicited. How are minimum wages initially established? The government follows one of 2 approaches, either appointing specialized committees to conduct investigations and recommend appropriate wages, or publishing detailed proposals for public feedback. Both methods ensure wage determinations are grounded in comprehensive research and meaningful stakeholder input before finalizing decisions. Who represents various interests in wage-setting committees? These committees maintain a balanced structure with equal representation from employer and employee groups, complemented by independent members, limited to 1/3 of total membership. This tripartite arrangement safeguards fair consideration of all perspectives during deliberations. What is the official process for announcing new minimum wages? After thorough evaluation of committee recommendations or public input, the government publishes an official notification in the Gazette that clearly specifies the revised minimum wages across different employee categories, detailing which industries, occupations, and geographical regions are affected. When do newly established minimum wage rates become enforceable? Unless the notification states otherwise, new wage rates take effect 3 months after official publication, providing employers sufficient transition time to update payroll systems and adjust financial planning. During this implementation window, the government often conducts targeted awareness initiatives. How frequently does the government review minimum wage standards? Standard practice requires review at least once every 5 years to maintain alignment with evolving economic conditions. However, exceptional circumstances such as significant inflation, economic downturns, or major market shifts may trigger special interim reviews. Familiarity with these procedural aspects empowers both employers and employees to effectively engage in the minimum wage determination process and adequately prepare for the implementation of revised rates. What is a floor wage and who establishes it? A floor wage represents the minimum payment workers must receive nationwide. The central government establishes this baseline according to essential living standards, ensuring workers can afford basic necessities like food, shelter, clothing, healthcare, and education. Can floor wages vary across different regions of India? Yes. The central government may set different floor wages for different geographical areas, acknowledging that living costs vary significantly across regions while still maintaining fundamental standards throughout the country. How do floor wages interact with state-established minimum wages? State governments must set their minimum wages at or above the floor wage level. The floor wage serves as a mandatory national baseline that all states must honor, guaranteeing workers receive at least the minimum income needed for basic sustenance. What happens when a state's existing minimum wage exceeds the floor wage? States with minimum wages already higher than the newly established floor wage cannot reduce these rates. This protection prevents workers from experiencing wage decreases when new floor wage standards are implemented. What purpose does the floor wage system serve? The floor wage system helps reduce wage disparities across India while respecting states' authority to establish higher wages. It aims to progressively improve living standards for all workers while recognizing regional economic differences. These provisions ensure all workers across India receive fair compensation that reflects local living costs while maintaining a guaranteed minimum standard nationwide. What is a floor wage and who establishes it? A floor wage is the minimum amount workers must be paid nationwide. The central government sets this baseline to ensure workers can afford essential necessities like food, housing, and healthcare. How does the government determine floor wage rates? The government follows a 5-step process: consulting expert advisors, engaging with state governments, analyzing regional living cost data, calculating appropriate wage levels based on this information, and officially publishing the final rates. Who participates in the consultation process? The central government consults with the Central Advisory Board, comprising employer representatives, worker representatives, and independent experts, and all state governments to gather diverse perspectives on regional economic conditions. What key factors influence floor wage calculations? The government considers regional living standards, current inflation rates, food and housing costs, economic variations across regions, and the essential needs of workers and their families throughout different parts of India. Can states establish their own minimum wages? Yes. States have authority to set their own minimum wages, provided they meet or exceed the national floor wage. States with existing higher minimum wages must maintain these higher standards even after new floor wage implementation. How are floor wages implemented and enforced? After determination, the government issues official notifications, provides implementation timelines, establishes monitoring mechanisms, and creates channels for workers to report underpayment violations. This information offers a basic overview of floor wages. Workers receiving less than the applicable floor wage should contact their local labor office for assistance and guidance. When is an employee entitled to a full day's wages despite working fewer hours? An employee must receive wages for a complete normal working day even when they work fewer than the standard hours if the reduction is because the employer failed to provide sufficient work. This protects workers from income loss in situations beyond their control, such as production slowdowns, material shortages, or equipment malfunctions. What exceptions apply to the full day payment requirement? An employee will not be entitled to a full day's wages when they refuse to work despite work being available. They voluntarily leave the workplace before completing normal hours. They report to work late without justified reason. Other specific circumstances as determined by the appropriate government authority. How does this provision apply in typical workplace scenarios? This rule protects workers when they are asked to leave early due to decreased production needs. They are present at the workplace but cannot work due to material shortages. Operations are temporarily suspended due to technical or mechanical issues. Assigned tasks are completed ahead of schedule within normal working hours. What obligations do employers have regarding this regulation? Employers must maintain detailed and accurate records of attendance and working hours to correctly determine when this provision applies. The responsibility lies with the employer to demonstrate that any exception to the full day payment requirement is legitimate and permissible under the law. These regulations ensure workers receive fair compensation while acknowledging legitimate circumstances where reduced payment may be warranted. Understanding these provisions helps both employers and employees ensure proper wage calculation and compliance with labor standards. Wages for two or more classes of work. Below are key questions and answers regarding wage calculations when employees perform different types of work with varying minimum wage rates. How are wages calculated when I perform multiple types of work in one day? When you perform different classes of work with distinct minimum wage rates, your employer must compensate you according to the time spent on each type of work at its respective minimum rate. Your total wages will be the sum of these separate calculations. What records must employers maintain for multiple classes of work? Employers must maintain precise time records documenting exactly how much time you spent on each type of work. This includes tracking start and end times for each distinct work category to ensure accurate wage calculation. Can employers average the different wage rates? No. Employers cannot average the different rates or compensate you at the lower rate for all work performed. Each type of work must be paid at its own applicable minimum rate based on the actual time spent performing those duties. How is this calculated in practice? For example, if you work as both a skilled technician, 200/hour, for 4 hours and as a helper, 100/hour, for 4 hours in one day, skilled work, 4 hours 200 equals 800 helper work, 4 hours 100 equals 400 total wages equals 1200. What happens if proper time records aren't maintained? The legal obligation of maintaining proper time records falls on the employer. If records are inadequate, disputes may be resolved in favor of the employee. Employers may face claims for wage differentials, statutory penalties, and other legal consequences. Who is responsible for tracking different work categories? While employees should remain aware of their work duties, the legal responsibility for implementing systems to accurately track different types of work rests entirely with the employer. This includes providing clear classifications of work types and their corresponding wage rates. What is the basic rule for paying piecework employees? Employers must pay piecework employees at least the applicable minimum time rate wage for all hours worked, regardless of how many pieces they produce. This ensures workers receive fair compensation for their time, even when their piece-based earnings would be lower. Why does this protection exist? This regulation safeguards workers against earning below minimum wage due to circumstances beyond their control such as machinery breakdowns, inferior materials, insufficient training, or workplace inefficiencies that might reduce their productivity. How is the minimum payment calculated? The calculation follows two steps. First, multiply the hours worked by the applicable minimum hourly rate. Second, compare this amount with the piece rate earnings. The employer must pay whichever amount is higher, ensuring workers always receive at least the minimum time-based wage. Can you provide an example? Consider a worker with a minimum time rate of 100 per hour who works 8 hours. their minimum guaranteed pay is 800. If they produce pieces that would only calculate to 650 at the established piece rate, the employer must still pay the full 800. Conversely, if their piece production equals 900, they receive the higher piece-based amount. What factors might legitimately affect a worker's piece output? Productivity can be affected by numerous factors including equipment maintenance and efficiency, material quality and consistency, worker experience and training level, environmental conditions, lighting, temperature, ventilation, task complexity, and production process design. The minimum wage protection acknowledges these variables are often outside workers' control. What records must employers maintain? Employers must keep detailed, accurate records documenting both hours worked and pieces completed by each employee. These records should be maintained for the legally required retention period and must clearly demonstrate compliance with minimum wage regulations. Workers are also advised to independently track their hours and production for verification purposes. What are the standard working hours under the code? The code establishes an 8-hour standard workday with required breaks for meals and rest. Employers must maintain accurate records of all working hours and comply with maximum limits. Are workers entitled to rest days? Yes. The code guarantees one rest day in every 7-day period for all employees. This ensures adequate recovery time and supports work-life balance. How are piecework employees compensated? Piece workers must receive at least the minimum time rate wages regardless of output. For example, at a minimum rate of 100 per hour, an 8-hour workday requires at least 800 payment, even if piece calculation would result in less. What if I'm asked to work on my rest day? Work performed on a designated rest day requires payment at no less than the overtime rate. This compensation must be paid within the regular payment cycle and properly documented. Are there special provisions for shift workers? Yes. Establishments operating continuously have special provisions for shift rotations and changeovers. Workers transitioning between shifts must receive adequate rest periods and appropriate compensation. When can working hour regulations be modified? Working hour regulations may be temporarily adjusted during exceptional circumstances like natural disasters or emergencies, with guaranteed appropriate compensation. 5 specific exemptions exist: emergency work, preparatory work, intermittent roles, technical processes requiring completion, and work dependent on natural forces. What records should employers maintain? Employers must keep accurate records of hours worked, pieces completed, for piece work, rest days provided, and compensation paid. These records demonstrate code compliance and protect both parties in case of disputes. These FAQs provide general guidance on labor regulations. Specific situations may require consultation with a legal professional or labor authority for detailed interpretation of the code. What constitutes emergency work under the code? Emergency work covers unforeseen situations requiring immediate attention, such as natural disasters, critical system failures, or urgent safety issues. These provisions allow for flexibility in working hours to ensure public safety and maintain essential operations during crisis situations. What is considered preparatory work? Preparatory work includes essential activities performed before or after regular hours to enable normal operations. Examples include equipment setup, systems testing, and pre-shift preparations. These activities are exempt from standard hour limits when they're necessary for the proper functioning of the workplace. How does the code define intermittent work? Intermittent work involves positions with significant idle periods between active tasks. Examples include security personnel, certain transportation roles, and on-call technicians. Since these jobs require presence but not continuous activity, they receive special consideration regarding working hour calculations and rest period requirements. When does technical completion apply? Technical completion covers processes that cannot be interrupted once started for technical, safety, or quality reasons. This includes chemical reactions, sensitive manufacturing processes, or specialized procedures where stopping midway would compromise results or create hazards. In these cases, extending beyond standard hours may be permitted. What work falls under natural forces provisions? This exemption applies to work governed by unpredictable natural elements rather than conventional schedules. Examples include agricultural harvesting, tide-dependent fishing, or weather-sensitive construction. These provisions recognize that some essential work must align with natural phenomena, requiring flexibility in scheduling and hour limitations. What is the minimum rate for overtime pay? Overtime must be paid at a minimum of twice, 2x, the normal wage rate. This higher rate applies to any work performed beyond the standard working hours. What are considered normal working hours? Standard working hours are typically 8 hours per day or 48 hours per week, as defined by the appropriate government. Any work beyond these limits qualifies for overtime compensation. How is overtime pay calculated? Overtime is calculated based on your basic rate of pay, not including allowances, bonuses, or other additional compensation unless your employment contract specifically states otherwise. When will I receive my overtime payment? Overtime pay must be included with your regular wage payments. It should appear clearly indicated on your wage slip as a separate entry. Can I take time off instead of overtime pay? In some establishments and with mutual agreement, you may choose to take compensatory time off instead of receiving overtime wages. This option is subject to specific conditions prescribed by regulations. Are all employees eligible for overtime pay? Not all employees qualify. Certain categories of workers, particularly those in managerial or supervisory positions, may be exempt from overtime provisions as specified under the code. What records must employers maintain about overtime? Employers must maintain detailed records of all overtime hours worked by each employee and the corresponding wages paid. These records must be available for inspection by labor authorities. Wage payments. What methods can employers use to pay wages? Employers may pay wages through 4 approved methods. Cash, using current coins or currency notes, checks, direct bank transfers to employee accounts, or electronic payment systems such as mobile wallets and UPI. For certain industries, the government may mandate payment exclusively by check or bank transfer. What documentation must accompany wage payments? All wage payments, regardless of method, must include detailed wage slips showing gross earnings, itemized deductions, and net payment. Employers must maintain comprehensive payment records for a minimum of 3 years, ensuring they remain accessible for labor official inspections. Can employers make deductions from wages? Only deductions specifically authorized by labor laws are permitted. Any unauthorized reductions from wages constitute a violation. Employers are legally obligated to pay wages in full within the timeframes established by labor regulations. What are the special requirements for cash payments? Cash payments require additional precautions including using only current legal currency, providing complete documentation with detailed pay slips, maintaining meticulous records, and implementing robust security measures to protect both the business and employees during the payment process. What penalties exist for non-compliance with payment rules? Failure to follow proper payment procedures can result in significant penalties, including substantial fines and potential imprisonment for serious or repeated violations. Employees have the legal right to file complaints regarding payment irregularities through designated labor authorities. How long must payment records be retained? All wage payment records must be preserved for the duration specified by law, typically a minimum of 3 years. These records should be systematically organized and readily accessible when requested during official labor inspections. About wages. What wage periods can employers establish? Employers may establish daily, weekly, fortnightly, or monthly wage periods, with none exceeding 1 month in duration. The selected wage period must align with industry standards and be explicitly documented in employment contracts. Any changes to established wage periods require proper notice to affected employees. How should wages be paid? Wages can be dispersed through current currency notes, bank checks, direct bank transfers, or approved electronic payment systems like UPI and mobile wallets. Each payment must be accompanied by comprehensive documentation including itemized wage slips detailing gross earnings, specific deductions, and net payment. When must wages be paid? Daily wages. Payment must be made at the conclusion of each work shift. Weekly wages. Payment must be completed on the final working day of the week. Fortnightly wages. Payment must be processed within 2 working days after the period ends. Monthly wages. Payment must be settled within 7 days of the subsequent month. Can different employees have different wage periods? Yes. Employers may implement varied wage periods for different employee categories based on job classification, operational requirements, and administrative efficiency. For instance, temporary workers might receive daily payments, while permanent staff may be on monthly payment schedules. What records must employers maintain? Employers must meticulously maintain all wage payment records for a minimum of 3 years as mandated by labor regulations. These records must be systematically organized and readily accessible for inspection by authorized labor officials upon request. Every employee must receive detailed wage statements showing complete calculation of their compensation. What happens if employers don't follow these rules? Non-compliance with payment regulations may result in significant penalties, including substantial fines and potential imprisonment for serious or recurring violations. Employees have legal recourse to file formal grievances with appropriate labor authorities regarding any payment discrepancies or delays. Wage payment regulations. What wage periods can employers establish? Employers may implement any of these 4 wage periods: daily, typically for casual labor and temporary workers; weekly, common in retail, hospitality, and manufacturing sectors; fortnightly, creating 26 payment cycles annually; monthly, the maximum allowed period. Standard for professional roles. All wage periods must be clearly communicated to employees and align with industry standards. What are the legal deadlines for wage payments? The Code on Wages, 2019 mandates these payment timelines. Daily wages. Payment due at shift end. Weekly wages. Payment due on the week's last working day. Fortnightly wages. Payment due within 2 days after period conclusion. Monthly wages. Payment due within 7 days of the following month. These deadlines are legally binding for all employers. When must final payments be made after employment ends? All wages and dues must be settled within 2 working days after employment termination, regardless of the circumstances. Dismissal from employment, retrenchment during workforce reduction, employee resignation, closure of the establishment. This includes all pending wages, unused leave encashment, and statutory dues to ensure financial security during employment transitions. What are the consequences of missing payment deadlines? Employers who fail to comply may face financial penalties under labor regulations, interest charges on delayed wage payments, administrative sanctions, legal proceedings initiated by affected employees. All employers must implement reliable payroll systems to meet these requirements, regardless of company size or industry. Wage payment regulations. Essential guidance on wage payment compliance under the Code on Wages, 2019 for both employers and employees. When must wages be paid based on payment frequency? Payment deadlines vary by wage period. Daily wages must be paid at shift end. Weekly wages by the week's last working day. Fortnightly wages within 2 days after period end. And monthly wages within 7 days of the following month. How quickly must final payments be made when employment ends? All wages and dues must be settled within 2 working days after employment termination, regardless of whether the employee was dismissed, retrenched, resigned, or affected by establishment closure. This includes all pending wages, leave encashment, and statutory dues. What additional compensation applies during retrenchment or closure? Beyond regular wages, affected employees are entitled to gratuity, if eligible, and compensation typically calculated at 15 days average pay for each completed year of continuous service. All settlements must be completed within 2 working days. What restrictions apply to wage deductions? Total deductions cannot exceed 50% of wages in any pay period and must be authorized under the code. Any payment an employee makes to their employer is legally considered a wage deduction. What are the consequences of non-compliance with payment regulations? Employers face penalties including interest payments on delayed wages, administrative fines, and potential legal action. Employees can seek remedies through labor courts or appropriate regulatory authorities. These regulations protect workers' financial security while establishing clear employer obligations. All businesses, regardless of size, must implement reliable payroll systems to ensure full compliance with these statutory requirements. Wage deductions. What types of deductions are legally permitted from my wages? Only deductions specifically authorized under the Code on Wages are allowed. These include mandatory deductions, income tax, provident fund contributions, voluntary deductions, insurance premiums, loan repayments, and other specific categories covered in subsequent slides. Any unauthorized deduction is illegal and subjects employers to penalties. When I make a payment to my employer, is this classified as a wage deduction? Yes, definitively. Any payment you make to your employer or their representative is legally classified as a deduction from your wages. This encompasses both direct monetary payments and indirect transfers of value, regardless of how the transaction is labeled or structured. Are disciplinary measures like withholding increments considered deductions? No. Financial consequences resulting from disciplinary actions for such as withholding salary increments, demotion to a lower pay grade, or suspension for are not legally classified as deductions if implemented with proper justification. However, employers must document these actions thoroughly and provide valid reasons that would stand up to scrutiny if challenged. How are advance salary payments or wage overpayments recovered? Recovery of advances or adjustment of overpayments must strictly follow procedures established under the Code on Wages. Typically, these amounts are recovered through reasonable installments spread across multiple pay periods to prevent undue financial hardship. Employers must clearly communicate the recovery schedule to affected employees. Is there a maximum limit on wage deductions? Yes, there is a strict limit. The total of all deductions in any wage period cannot exceed 50% of your total wages, with very few exceptions specifically outlined in the law. This protective cap ensures workers retain sufficient earnings to meet their essential living expenses and financial obligations. Authorized wage deductions. What deductions can be made for misconduct or rule violations? Your employer may deduct fines when you violate workplace policies. These deductions must follow authorized procedures, be properly documented, and be clearly communicated to you in advance. Can my employer deduct pay for unauthorized absences? Yes, deductions are permitted for unauthorized absences, including unapproved leave, tardiness, early departures, or unexplained absences that affect workplace operations. The amount typically corresponds to your time missed. When can deductions be made for damages or losses? If you're responsible for goods that were damaged or lost due to your negligence, or if you're accountable for missing funds, your employer may make deductions. This requires proper investigation and evidence that the loss directly resulted from your actions. Are housing-related deductions legal? Yes. Deductions for employer-provided housing are authorized, including rent, maintenance fees, utilities, and related expenses. These deductions are considered part of your compensation package when housing is provided as an employment benefit. What other services can be deducted from my wages? Your employer may deduct costs for services they provide, such as meals, transportation, uniforms, equipment, medical facilities, and child care. These deductions must be agreed upon in your employment contract or through collective agreements. Remember, all wage deductions must comply with labor laws, be properly documented, and cannot exceed 50% of your total wages in any pay period unless specifically permitted by law. Essential information about authorized deductions from employee wages explained in clear, straightforward terms. What disciplinary deductions can employers legally make? Employers may deduct wages for workplace misconduct fines, unauthorized absences, tardiness, early departures, and damages losses caused by employee negligence. These deductions require proper documentation and must be clearly communicated to affected employees. What housing and service deductions are permitted? Deductions are allowed for employer-provided accommodations, meals, transportation services, uniforms, equipment usage, and other welfare benefits that have been explicitly agreed upon in your employment contract or collective agreement. Which financial deductions are authorized by law? Legal financial deductions include recovery of salary advances, repayment of employer-provided loans, personal, home, or emergency loans, and payments to cooperative societies. All repayment terms must be transparently communicated before implementation. What mandatory statutory deductions must be withheld? Statutory deductions include income tax, professional tax, social security contributions, provident fund, pension, health insurance, and court-ordered payments such as maintenance or child support. These are legally required regardless of employee consent. Are there limits on total wage deductions? Yes. Total deductions generally cannot exceed 50% of an employee's wages in any pay period. This cap protects financial stability, though exceptions with government approval may exist for cooperative society payments or loan recovery. What documentation should accompany wage deductions? All deductions must comply with applicable labor laws and be properly documented. Employees should receive detailed pay statements that clearly itemize each deduction type, amount deducted, and any remaining balance for ongoing deductions like loans. What types of wage deductions are legally authorized? Legally authorized deductions include recovery of advances, loan repayments, taxes, social security contributions, cooperative society payments, trade union fees, railway loss recovery, for railway employees, relief fund contributions, housing accommodation charges, amenity service fees, and court-ordered payments. All deductions must comply with labor laws and be properly documented. Is there a limit to how much can be deducted from my wages? Yes. The total deductions in any wage period cannot exceed 50% of your wages. In exceptional cases with government approval, this limit may be exceeded for cooperative society payments or loan recovery. This cap protects you from excessive deductions that could impact your financial stability. Can my employer impose fines as wage deductions? Yes, but with strict limitations. Fines can only be imposed for government-approved acts specified by official notice. Total fines cannot exceed 3% of wages in any pay period. You must be given an opportunity to explain yourself before any fine is imposed. Fines cannot be imposed on workers under 15 years of age or after 60 days from the incident. All fines must be recorded in a fine fund used for employee benefits. Do I need to authorize all deductions from my wages? Not all deductions require your explicit authorization. Statutory deductions like taxes and court-ordered payments are mandatory. However, deductions such as trade union fees require your written consent. For advances and loans, accepting these benefits implies consent to the related deductions, though terms should be clearly communicated beforehand. What information should my pay statement include about deductions? Your pay statement must clearly itemize all deductions from your wages. This includes the type of each deduction, tax, loan repayment, etc., the amount deducted, and the remaining balance. For ongoing deductions like loans, clear and transparent wage calculations allow you to understand exactly how your net pay is determined. Fines and wage deductions. What acts can an employer impose fines for? Employers may only impose fines for specific acts and omissions approved by the appropriate government. These must be directly employment related, clearly defined in employment terms, and displayed prominently on premises in languages workers understand. Fines for arbitrary or undefined reasons are strictly prohibited. What process must employers follow before imposing a fine? Employers must provide employees with an opportunity to present their defense. This includes issuing written notification about the alleged violation and allowing 3 to 7 days for the employee to explain their perspective before making a final determination. Is there a limit on how much can be deducted as fines? Yes. The total fines in any wage period cannot exceed 3% of wages. This cap applies to all combined fines during that period, ensuring employees are protected from excessive financial penalties that could impact their livelihood. Are there any age restrictions on imposing fines? Yes. Fines cannot be imposed on employees under 15 years of age. This special protection aligns with child labor laws that prioritize the welfare and development of young workers. What happens to the money collected from fines? All fines must be documented in a prescribed register and deposited into a fine fund. This fund may only be utilized for employee benefit purposes approved by the prescribed authority. Is there a time limit for imposing fines? Yes. Fines must be imposed within 60 days from when the act or omission occurred. This ensures timely disciplinary actions and prevents indefinite liability for past incidents. These regulations create a balance between maintaining workplace discipline and protecting employees from arbitrary or excessive penalties. For guidance on specific situations, consult your HR department or a legal professional. Deductions for absence. When can an employer deduct wages for absence? Deductions are permissible only when an employee is absent from their designated workplace during mandatory working hours. This applies to both full-day absences and partial absences within a workday. All such deductions must strictly comply with the Payment of Wages Act and relevant labor regulations to be considered legitimate. How is the deduction amount calculated? The deduction must be strictly proportionate to the duration of absence. This proportionality principle ensures that the percentage of wages deducted cannot exceed the percentage of scheduled work time missed. For example, if an employee misses 2 hours of an 8-hour shift, 25% of working time, the maximum permissible deduction is limited to 25% of their daily wage. What special provisions apply to collective absences? When 10 or more employees are absent simultaneously without reasonable cause or proper notice, employers may impose additional deductions equivalent to up to 8 days' wages as compensation for operational disruption. This provision specifically addresses collective absences that substantially impact workplace productivity and organizational functioning. What documentation must employers maintain for absence deductions? Employers are required to maintain comprehensive attendance records that meticulously document all absences. Each deduction must be properly recorded in wage statements with specific dates, precise durations of absence, and transparent calculation methods. These records serve as essential documentation justifying any wage deductions implemented. Are employers required to notify employees about deductions? Yes. Prior notification is mandatory. Employers must inform employees about both the specific reason for and the exact amount of any planned deduction before it is applied to their wages. Employees retain the right to contest any deductions they consider unreasonable through appropriate workplace grievance procedures. These carefully designed regulations establish a balanced framework that protects workers from excessive financial penalties while allowing employers to address unauthorized absences and maintain necessary workplace discipline and productivity standards.
What types of wage deductions are legally permitted? 3 primary categories are allowed. 1. Deductions for workplace absence, 2. Deductions for damage or loss resulting from employee negligence, and 3. Deductions for employer-provided services and recovery of advances. How are deductions calculated for employee absences? The principle of proportionality applies for deductions cannot exceed the percentage of work time missed. For instance, if you miss 2 hours of an 8-hour shift, the maximum deduction allowed is 25% of your daily wage. For simultaneous absences involving 10 or more employees, employers may deduct up to 8 days' wages as compensation for operational disruption. What process must employers follow when deducting for damage or loss? Employers must 1. Limit deductions to the actual value of the damage. 2. Provide the employee an opportunity to explain the circumstances. 3. Maintain detailed records in a designated register for 3 years. 4. Cap significant deductions at 25% of monthly wages. And 5. Initiate deductions within 6 months of the incident. What service-related deductions are permitted? Employers may deduct for services such as company housing, utilities, meals, and transportation. These deductions must not exceed the actual value of services provided and require explicit written authorization from the employee before implementation. What rules govern deductions for advances? Advances may be recovered from the first wage payment, if provided before employment begins, or according to agreed terms. Interest rates must be reasonable and clearly communicated. The combined total of all deductions cannot exceed 50% of monthly wages, and comprehensive documentation must be maintained. What documentation is required for all deductions? All deductions require proper documentation, including itemized wage statements detailing each deduction separately. Employers must maintain attendance records for absence-related deductions, damage-loss registers, and written authorizations for service deductions and advances. These regulations establish a balance between an employer's right to recover costs and an employee's protection from excessive or arbitrary deductions. Employees retain the right to challenge any deductions they consider unreasonable through established grievance procedures. What types of deductions can my employer legally make from my wages? Your employer can make 3 types of deductions. 1. For damage or loss caused by your negligence. 2. For employer-provided services such as housing and meals. And 3. For recovery of advances. Each category has specific legal limitations and procedural requirements. Is there a maximum limit on wage deductions? Yes. Total monthly deductions cannot exceed 50% of your wages under any circumstances. For damage-related deductions specifically, recovery is capped at 25% of your monthly wages if the amount is substantial. Can my employer deduct for damages without a fair process? No. Before making any damage or loss deduction, your employer must provide you with an opportunity to explain your side. They must conduct a proper inquiry where you can present your defense and explain the circumstances fully. What is the time limit for employers to make damage-related deductions? Employers must make deductions for damage or loss within 6 months from the date the incident occurred. Any attempt to recover such amounts after this period through wage deductions is not permitted. Are deductions for employer-provided services automatic? No. All deductions for services like company housing, utilities, meals, or transportation require your explicit written authorization before implementation. These deductions cannot exceed the actual value of services provided. How are advances recovered from wages? Advances given before employment may be recovered from your first wage payment. For advances during employment, recovery follows agreed terms. Interest rates must be reasonable, transparently communicated, and properly documented in your employment records. Do these deduction regulations apply to government employees? These provisions apply to government establishments only when specifically notified by the appropriate government authority. The government may modify these provisions when applying them to its establishments. Important: your employer must provide itemized wage statements clearly showing each deduction separately, and maintain comprehensive records of all deductions in a prescribed register for a minimum of 3 years. You have the right to contest any deduction you believe is unreasonable or improper. Loans and government establishments. What conditions apply to employee loan deductions? Employee loan deductions must adhere to specific regulations including limitations based on employment tenure and salary grade, interest rates below standard banking rates, clearly defined repayment schedules, maximum deduction thresholds, and comprehensive documentation. Employers must maintain detailed records of all loan transactions and provide statements to employees when requested. Are there limits on loan interest rates that employers can charge? Yes. Employers cannot charge interest rates exceeding standard banking rates on employee loans. This regulation prevents employers from using loans as a profit-generating mechanism rather than an employee benefit. What documentation is required for employee loans? Employers must maintain formal loan agreements with comprehensive documentation of all transactions. To ensure transparency, employers are obligated to provide detailed loan statements whenever employees request them. Do these provisions automatically apply to government establishments? No, government establishments are not automatically subject to these provisions. They only become applicable when the appropriate government explicitly notifies and extends such provisions to specified government entities. Can the government modify these provisions for its establishments? Yes, the appropriate government has the authority to modify these provisions when applying them to government entities. Strategic departments may receive special exemptions, and regulations may vary between central and state government establishments. How are employees informed about applicable loan provisions in government establishments? Government establishments must display all applicable notifications in prominent locations throughout their premises, ensuring employees are fully aware of the specific provisions that govern their workplace. Bonus eligibility. Who is eligible to receive a bonus? All employees earning below the notified wage ceiling who have worked at least 30 days in an accounting year qualify for a bonus. These 30 days need not be consecutive, making part-time and seasonal workers eligible if they meet this threshold. What is the minimum bonus payable? Eligible employees are entitled to a minimum bonus of 8.33% of their annual wages or 100, whichever is higher. This minimum is guaranteed regardless of the company's financial performance. How is bonus calculated for higher wage earners? For employees whose wages exceed the notified ceiling, bonus calculation is capped at the ceiling amount or minimum wage, whichever is higher. Only basic pay and dearness allowance are included in this calculation, while other allowances are excluded. Can employees receive more than the minimum bonus? Yes, when the allocable surplus, calculated from gross profits after specified deductions, exceeds the minimum bonus requirement, employers must distribute higher bonuses proportionate to wages, up to a maximum of 20% of the employee's annual wages. What conduct can disqualify an employee from receiving a bonus? Employees dismissed for fraud, violent behavior, theft, misappropriation, or sabotage of company property forfeit their bonus eligibility, but only for the accounting year in which the dismissal occurs. Minor misconduct does not affect bonus eligibility. These guidelines outline the core principles of bonus eligibility under the Payment of Bonus Act. For organization-specific policies, employees should consult their HR department. Payment of bonus. Who qualifies for the minimum bonus? All employees earning below the notified ceiling who have worked for at least 30 days in an accounting year are entitled to a minimum bonus of 8.33% of their wages or 100, whichever is higher. The 30-day requirement may be cumulative and need not be continuous employment. How is bonus calculated for employees earning above the wage ceiling? For employees whose wages exceed the notified ceiling amount, the bonus is calculated as if their wage were equal to the ceiling amount. This calculation includes basic pay and dearness allowance, but specifically excludes other allowances and benefits. What is the maximum bonus an employee can receive? The maximum statutory bonus payable is 20% of the employee's annual wages, regardless of company profitability or individual performance metrics. Any payment exceeding this percentage is legally classified as an ex gratia payment, not a bonus under the Act. How are performance-based bonuses determined? Bonuses exceeding the minimum 8.33% that are based on production or productivity metrics must be established through a formal written agreement between employers and employees. These agreements require official registration with the appropriate government authority to be legally valid. What bonus amount applies for partial year employment? Employees who haven't completed the full accounting year receive proportionately reduced bonus amounts. The calculation follows the formula: eligible bonus equals full bonus amount, X, days worked percent total working days. A minimum of 30 working days remains the threshold for any bonus eligibility. What special provisions apply to newly established businesses? New establishments benefit from special provisions during their first 8 accounting years. For the initial 5 years, bonuses aren't mandatory if the business reports no profit. From the 6th through 8th year, bonuses become payable only when the establishment generates profit, calculated at reduced percentages as specifically prescribed in the Act. What forms of misconduct can disqualify an employee from receiving a bonus? An employee may forfeit bonus eligibility if dismissed for serious misconduct, including fraud, riotous or violent behavior, theft, misappropriation, or sabotage of company property. This disqualification applies exclusively to the accounting year in which the dismissal occurred. Employers are legally required to maintain detailed documentation of all bonus calculations and disbursements for a minimum period of 10 years, or until all related disputes are conclusively resolved. These records must remain accessible for inspection by authorized labor officials upon official request. Proportionate reduction in bonus. What happens to my bonus if I haven't worked the entire accounting year? your bonus will be proportionately reduced based on your actual working days. The calculation follows: eligible bonus equals full bonus amount, x days worked percent total working days in year. This ensures equitable compensation between full year and partial year employees. Is there a minimum work requirement for bonus eligibility? Yes. You must have completed at least 30 working days within the accounting year to qualify for any bonus under the Payment of Bonus Act. This threshold applies universally regardless of position or salary grade. How is the proportionate reduction practically applied? The reduction follows a straightforward pro rata calculation based on your attendance record. For instance, in an accounting year with 240 working days, 180 days worked, 75% attendance, you receive 75% of the eligible bonus amount. 120 days worked, 50% attendance, you receive 50% of the eligible bonus amount. 60 days worked, 25% attendance, you receive 25% of the eligible bonus amount. Does this reduction apply to all bonus categories? This proportionate reduction applies to both the statutory minimum bonus, 8.33% of wages, and any higher performance-based or productivity bonuses your employer might offer. The principle of pro rata calculation based on days worked remains consistent across all bonus types covered under the Act. Employees with partial year service receive proportionately reduced bonuses calculated as the ratio of their actual working days to the total working days in the accounting year. To qualify for any bonus payment, a minimum of 30 working days is mandatory under the provisions of the Act. Working days for bonus. What periods count as working days for bonus calculations? All legitimate absences are included as working days, including layoffs, paid leave, annual, casual, sick, accident leave, maternity leave, training periods, and participation in legal strikes. Does maternity leave affect my bonus eligibility? No. Maternity leave, including pre-delivery and post-delivery rest periods, is fully counted as working days for bonus calculation purposes as long as it complies with applicable employment laws. How do workplace injuries impact my bonus? Absences due to temporary disablement from workplace accidents are counted as working days. This protection covers all recovery periods for injuries sustained during employment, whether they occurred on company premises or while performing work duties elsewhere. Am I eligible for bonus during temporary layoff periods? Yes. Layoff periods that occur under a formal agreement or as permitted by law are counted as working days. This includes temporary suspension of employment due to business circumstances, where your employment relationship remains intact. Is time spent in training considered for bonus calculation? Yes. Time dedicated to employer-approved training or professional development programs is fully counted as working days when calculating bonus eligibility. How do strikes or lockouts affect bonus eligibility? Any period during which you couldn't work due to a legal strike or lockout, provided it wasn't declared illegal by authorities, counts as working days for bonus calculation purposes. These provisions ensure that employees with legitimate absences receive fair treatment regarding bonus eligibility. Employers are required to maintain comprehensive attendance records to accurately implement these regulations in accordance with labor laws. FAQs. Bonus disqualification. When can an employee be disqualified from receiving a bonus? An employee may be disqualified if dismissed for specific misconduct, regardless of performance or tenure. This disqualification applies from the dismissal date and may affect bonus eligibility for the entire accounting year. What types of fraud can lead to bonus disqualification? Disqualifying fraudulent activities include falsifying documents, misrepresenting qualifications, manipulating attendance records, submitting false expense claims, or engaging in any deceptive practice intended to obtain undue benefits or advantages. How is violent behavior defined for bonus disqualification purposes? Violent behavior encompasses riotous or violent conduct on company premises, including physical assault, intimidation, threats, deliberate property damage, or creating a hostile work environment that compromises the safety and well-being of colleagues. What constitutes theft or sabotage for bonus disqualification? Theft or sabotage includes misappropriation of company assets, physical property, intellectual property, or confidential information, or deliberate tampering with equipment, systems, or processes with intent to disrupt operations or cause financial harm to the organization. How is sexual harassment defined in the context of bonus disqualification? Sexual harassment includes unwelcome sexual advances, requests for sexual favors, verbal or physical conduct of a sexual nature, creating an intimidating or offensive work environment, or making submission to or rejection of such conduct a factor in employment decisions. FAQs. Multi-department establishments. And bonus calculations. How are different departments treated for bonus calculations? All departments, undertakings, and branches are generally considered parts of the same establishment when calculating bonuses. This ensures a consistent bonus calculation methodology across the entire organization. When can a department be considered separate for bonus purposes? A department may be treated separately if it maintains independent financial records, including its own balance sheet and profit-loss account for the relevant accounting year. This provision recognizes units with financial autonomy. What conditions must be met for separate departmental treatment? The department must not have been previously treated as part of the main establishment for bonus calculations in the preceding accounting year. This prevents selective treatment designed to minimize bonus payments. What is the process for requesting separate treatment of a department? Employers must submit the department's distinct financial statements to the appropriate authority before the bonus calculation deadline, along with documentation demonstrating the unit's operational independence. Period. Does separate treatment for bonus calculations make departments independent entities? No. Even when treated separately for bonus calculations, all units remain part of the same legal entity for other labor law compliances. The parent company retains ultimate responsibility for regulatory compliance across all units. Why does the law generally favor treating all departments as one establishment? This approach promotes equity among employees across different units of the same organization. It prevents situations where workers performing similar duties might receive substantially different bonuses based solely on departmental assignment. What records should multi-department organizations maintain? Organizations should document their organizational structure, departmental classifications, and bonus calculation methodologies. This documentation ensures regulatory compliance and facilitates transparent communication with employees regarding bonus determinations. Allocable surplus. Below are common questions about how allocable surplus is calculated and distributed for employee bonus payments. What is allocable surplus? Allocable surplus is the portion of a company's available profits that must be specifically designated for employee bonuses. It represents the financial pool from which all bonus payments are distributed. How much surplus must be allocated for bonuses? Banking companies must allocate 60% of their available surplus for bonuses, while all other establishments must allocate 67%. These percentages are established by law and are non-negotiable. Can companies modify these allocation percentages? No. These percentages, 60% for banking companies and 67% for other establishments, are statutorily mandated and must be followed by all employers covered under the code, regardless of their profit margins or financial circumstances. When must the allocable surplus be determined? Calculations must be completed annually based on the available surplus from the previous accounting year. Employers are legally required to calculate and distribute the allocable surplus within 8 months from the end of the accounting year. Are financial statements verified during bonus calculations? Audited financial statements are generally accepted at face value. However, if disputes arise regarding bonus amounts, authorities may examine the balance sheet while maintaining strict confidentiality of sensitive business information. What happens if financial records are manipulated to reduce bonus payments? If evidence suggests financial statements have been manipulated to reduce bonus obligations, regulatory authorities can mandate a recalculation based on adjusted figures. Companies are legally required to maintain transparent and accurate accounting practices. What are the consequences of late bonus payments? Failure to calculate or distribute the allocable surplus within the 8-month deadline may result in significant penalties under the code. Timely calculation and payment of bonuses is not just good practice, but a legal requirement. Allocable surplus constitutes the legally mandated portion of available profits, reserved exclusively for employee bonuses, 60% for banking institutions and 67% for all other establishments. While calculations typically rely on audited financial statements that aren't questioned, regulatory authorities may examine these records if disputes arise, always maintaining appropriate confidentiality. FAQs. Understanding bonus calculations. Key questions about gross profit calculation and available surplus determination for bonus distribution. Q. How are gross profits calculated under the code? A. Gross profit calculation methods vary by establishment type. For banking companies, calculated as per central government notifications, generally using the formula operational income minus operational expenses. For other establishments, typically derived by adding back specific items, depreciation, donations, direct taxes, to the net profit, following central government prescriptions. Q. What constitutes available surplus in bonus calculations? A. Available surplus represents the actual funds available for bonus distribution. It's determined by deducting all prior charges specified in Section 34, including depreciation, direct taxes, and other prescribed amounts, from the gross profits for an accounting year. This calculation must be completed within 3 months of the accounting year's conclusion. Q. Why is documentation essential for gross profit calculations? A. Proper documentation of all revenue and expense items is mandatory because calculations must adhere to standardized accounting principles. All figures must be transparent and verifiable through accounting records. This documentation ensures equitable bonus distribution and code compliance. Q. What is the additional component referenced in the code? A. The additional component is a tax adjustment mechanism introduced by the code. Following the code's implementation, available surplus also incorporates the difference between direct tax on gross profits for the current year and direct tax on gross profits after deducting the previous year's bonus. Q. Could you illustrate the additional component with an example? A. Consider this example. If direct tax on gross profits before bonus equals 1 million and direct tax on gross profits after bonus deduction equals 850,000, the resulting difference of 150,000 would be added to the current year's available surplus. This adjustment prevents double taxation since bonus payments qualify as tax-deductible expenses. Q. What is the deadline for completing available surplus calculations? A. Available surplus calculations must be finalized within 3 months after the accounting year ends. This timeline ensures timely bonus payments to eligible employees. Deductions from gross profits. Essential clarifications about the mandatory deductions from gross profits before calculating employee bonus amounts. What are the main categories of deductions from gross profits? Before calculating the allocable surplus for bonus distribution, 3 mandatory categories of deductions must be made from gross profits as prior charges. Depreciation allowances as permitted under applicable tax laws. Direct tax liabilities payable by the employer. Other prescribed sums including development rebates and returns on invested capital. What types of depreciation qualify for deduction? Any depreciation permissible under the Income Tax Act or agricultural income tax law can be deducted. This encompasses depreciation on tangible assets, buildings, machinery, furniture, vehicles, amortization of intangible assets, patents, copyrights, trademarks. Additional depreciation allowances for newly installed manufacturing equipment. Employers may apply either straight-line or written-down value methods in accordance with prevailing tax regulations. Which direct taxes are considered deductible prior charges? All direct taxes that an employer is liable to pay for the accounting year on their income, profits, and gains qualify for deduction. These include corporate income tax at the applicable statutory rate, surcharge, and education cess components of income tax, minimum alternate tax, MAT, where applicable under tax provisions. Any additional tax liabilities arising from assessments for that specific accounting year. What constitutes the other sums category of deductions? The other sums category encompasses several government-prescribed deductions, including development rebate or investment allowance reserves created in compliance with income tax provisions, direct tax provisions specifically related to the employer's income and profits, any amounts explicitly notified as deductible by the central government, returns on invested capital and equity shares calculated at prescribed rates. Why are these deductions essential before calculating bonus? These deductions ensure that only genuine operational surplus is factored into bonus calculations. This balanced approach simultaneously safeguards business sustainability and enables fair profit distribution among employees by accounting for necessary business expenses and statutory obligations before determining the amount available for bonus payments. Who establishes the parameters for these deductions? The rates, methodologies, and specific items eligible for deduction are primarily determined by provisions of the Income Tax Act and related regulations. Applicable agricultural income tax laws. Official notifications issued by the central government through the Official Gazette. Employers must strictly adhere to these prescribed guidelines when calculating deductions from gross profits to ensure compliance with bonus distribution regulations. Set on and set off. Below are common questions about the set on and set off mechanisms that regulate bonus calculations across multiple accounting years. What are set on and set off provisions? These are balancing mechanisms that stabilize bonus payments across financial cycles. Set on allows employers to carry forward excess allocable surplus during profitable years, while set off permits recovery of bonus deficiencies in subsequent years when profits were insufficient to meet minimum bonus obligations. What is the maximum period for carrying forward amounts? Both excess allocable surplus, set on, and deficiencies, set off, can be carried forward for a maximum of 4 consecutive accounting years. Once this period expires, these amounts lapse and cannot be factored into future bonus calculations. Is there a limit to the amount that can be carried forward? Yes. Under the set-on provision, the maximum amount that can be carried forward is capped at 20% of the employee's wage salary eligible for bonus. Any surplus exceeding this threshold cannot be utilized for future bonus calculations. How are carried forward amounts applied? These amounts are applied following the first in first out (FIFO) principle. This ensures that the oldest carried forward amount, from the earliest applicable year, is utilized first before proceeding to more recent allocations. What record keeping is required for these provisions? Employers must maintain dedicated registers documenting year-wise allocations of set-on and set-off amounts. These records require verification by both employer and employee representatives, and must be properly disclosed in financial statements in accordance with applicable accounting standards. What advantages do these provisions offer? For employers, these provisions provide crucial financial flexibility during business downturns. For employees, they help stabilize bonus payments across economic cycles, preventing severe fluctuations in bonus income regardless of the company's short-term financial performance. A thorough understanding of these provisions ensures equitable bonus distribution while effectively balancing the financial interests of both employers and employees across different economic cycles. FAQs, adjustment of customary bonus. Essential questions about how customary or festival bonuses interact with statutory bonus requirements. What is the adjustment of customary bonus? This provision enables employers to offset any customary or festival bonuses already distributed against the statutory bonus obligation for the same accounting year. This prevents double payment and recognizes employers who regularly provide cultural or traditional bonuses. Which types of bonuses qualify for adjustment against statutory bonus? Any customary or festival bonus qualifies, including, but not limited to, Diwali, Puja, Onam, or Christmas bonuses, traditional year-end rewards, productivity incentives, or any advance payments specifically designated against the statutory bonus requirement. How precisely is the adjustment calculated? The calculation follows a straightforward one-to-one deduction principle. For instance, if an employer has paid $2,000 as a Diwali bonus, and the calculated statutory bonus amounts to $5,000, the employer may deduct the $2,000 and distribute only the remaining $3,000 as the statutory bonus. Can multiple customary bonuses throughout the year be combined for adjustment? Yes. If multiple cultural or festival bonuses were paid within the same accounting year, for example, $1,500 for Diwali and $1,200 for New Year, the aggregate amount, $2,700, can be deducted from the statutory bonus obligation. Is it permissible to carry forward customary bonus adjustments to subsequent accounting years? No. The adjustment provision is strictly limited to the accounting year in which the customary bonuses were distributed. Excess payments cannot be carried forward as credits against future statutory bonus obligations. What record-keeping requirements apply to these adjustments? Comprehensive documentation of all customary bonus payments must be maintained, including payment vouchers, disbursement dates, purpose descriptions, recipient acknowledgements, and clear designation of the festival or occasion. These records may be required during labor inspections or in case of disputes. This balanced provision honors cultural traditions while ensuring statutory compliance. It allows employers to maintain festival and customary reward practices without financial duplication, provided all adjustments are properly documented and applied exclusively within the relevant accounting year. FAQs, deduction of losses from bonus. Clear answers about how employers can deduct financial losses caused by employee misconduct from bonus payments. When can an employer deduct losses from an employee's bonus? An employer can deduct losses only when an employee's misconduct directly caused financial loss to the company. This misconduct must occur in the same accounting year as the bonus calculation. Proper disciplinary proceedings where the employee had a fair opportunity to defend themselves are mandatory. Is there a limit to how much can be deducted? Yes. The deduction cannot exceed the total bonus amount payable to that employee for that accounting year. If the loss exceeds the bonus amount, employers cannot recover the additional amount from future bonuses or other compensation. What happens if the loss is less than the bonus amount? If the financial loss is less than the bonus amount, the employee must receive the remaining balance. For example, if the bonus is $10,000 and the proven loss is $3,000, the employee is entitled to receive $7,000 within the standard payment timeline. Can losses be carried forward to next year's bonus? No. Deductions can only be made from the bonus for the accounting year in which the loss occurred. The code strictly prohibits carrying forward deductions to subsequent years, even when losses exceed the current year's bonus amount. What documentation must employers maintain? Employers must keep detailed records of the misconduct, including disciplinary proceedings, evidence of financial loss, calculations showing how the loss amount was determined, and records of the corresponding bonus deduction. These records may be required during inspections or if disputes arise. This provision balances employer interests with employee rights. Deductions must be proportionate to the actual loss caused and cannot be used as punitive measures beyond recovering the documented financial damage. Bonus payments. Essential information about bonus payments under the code explained in clear, accessible language. When must employers pay the bonus to employees? Employers must disburse bonuses within 8 months after the accounting year ends. For instance, if the accounting year concludes on March 31st, the bonus payment deadline is November 30th of the same year. All payments must be transferred directly to the employee's bank account. Can the payment deadline be extended? Yes, in exceptional circumstances such as financial hardship or natural disasters, the government may extend the payment period for up to 2 years. Employers seeking this extension must submit a formal application with comprehensive supporting documentation. What happens if there's a dispute about the bonus amount? During a dispute, employers must still pay the minimum statutory bonus of 8.33% of wages within the standard 8-month timeframe. Once the dispute is resolved, any additional bonus amount must be paid within 1 month of the settlement or award becoming final. Can employers deduct money from bonuses? Yes. If an employee's misconduct directly caused financial loss to the employer within the same accounting year, that loss amount may be deducted from the employee's bonus. The employee remains entitled to any remaining bonus amount after the deduction is applied. What are the limitations on deducting losses from bonuses? Deductions are strictly limited to the accounting year in which the loss occurred and cannot be carried forward. The misconduct must be proven through proper proceedings, and the deduction must be proportionate to the actual financial loss. Employers must maintain thorough documentation of both the misconduct and the resulting financial impact. What recourse do employees have if they don't receive their bonus on time? Employees can file a formal claim with the appropriate regulatory authority within 2 years from the date the bonus was due. Upon review, the authority may direct the employer to pay both the outstanding bonus and accrued interest at the prescribed rate. How long must employers retain bonus payment records? Employers are required to preserve comprehensive records of all bonus calculations and payments for a minimum of 5 years. These records must clearly document the calculation methodology, eligible employees, specific bonus amounts, and exact payment dates.